Okay, it looks like you're both ready. I'm going to start with you, Ms. Baumgartner. If you would mind just please doing a quick sound check with Justice Apple on the other end.
Oh, I'm not hearing.
Good afternoon.
Thank you. I do hear that. Thank you.
Thank you. And now we will move on to Mr. Blades, and you can give a quick sound check, and then you may proceed with your argument.
Good afternoon, Justice Apple. Can you hear me?
Good. Yeah, good afternoon. Thank you.
Thank you.
Thank you. You may proceed.
Thank you. May it please the court, Charles Blades, on behalf of the defendant, Megan Dorothy, the appellee, and now the applicant at this point. The district court in this case granted our motion for summary judgment on two distinct grounds. The one being the statutory ground involving the application of Iowa Code 8535-9 and 8520. And then also separately granted a summary judgment on the contractual argument involving the language of the settlement documents that were agreed to between the parties to the underlying workers' compensation claim. District court holding that the settlement documents, the language was clear and unambiguous, including referencing language in the separate or the additional terms of settlement document that was submitted, stating that the claimant releases all claims against not only the employer and the insurance carrier in the work comp claim, but also any employee of the defendant employer, as well as other persons, officers, directors, other entities, and so forth. Releases significant to this matter is that those documents clearly and unambiguously release claims involving injuries suffered by the claimant as a result of a workplace injury, including those claims against a employee.
Mr.
Yes.
Blades, I'm over here, sorry. The settlement agreement document has a caption at the top of it, and it doesn't specifically reference your client here. What is it about this document that you argue would make this document apply to your client? I mean, isn't this something that was specifically made for the Workers' Compensation Commissioner to approve?
Well, the document actually consists of, and I think it's worth highlighting that there's actually two different documents in play. The first one is the form document that's used for settlements under 85.353, and then there's this additional terms document that again states it releases employees. Now,
that document, though, has a caption at the top of it, doesn't it?
It does, but that doesn't take away from the fact that it's still a settlement contract. This document has life separate and apart from whatever the Workers' Compensation Commissioner would do with it, approve it. The document, the additional terms document, really isn't even needed in order to get the approval of the commissioner.
Yeah, I think that may be right. But why did you submit it then?
Well, the intent was with the additional terms to capture and to broaden the scope of that settlement agreement, including capturing potential claims that may exist against employees and others, officers, directors, subsidiaries, related companies, and so forth. Now, I'm not aware of any authority out there that says that settlement documents submitted to the Workers' Compensation Commissioner are strictly limited for use as to the workers' compensation claim. We haven't come up with any such authority in any of our research, and none has ever been asserted by the opposing party in this case.
In contract terms, your argument would be that Dorothy is a third-party beneficiary of the contract. Is that what we would be saying in contract terms?
I don't think that's quite accurate. I don't want to mince words with you because I guess that argument could exist, but when you have language in a settlement contract, which is at heart what this is, setting aside that it's also being submitted for approval by the settlement document that says clearly as to claims of injury arising from the same workplace incident against employees, any employee, I think that makes Dorothy a direct beneficiary of the settlement contract.
We're saying the same thing.
Possibly, yes. The other thing I think is worth highlighting, of course, is that this settlement agreement, including the 8535-3 settlement form and the additional terms, was agreed to and signed by not only the claimant, but the claimant's attorney. And so I'm not sure what, if you're looking at language that's really clear, as the district court found, unambiguous, and as Judge May found before in the Court of Appeals, and I haven't seen anything in any of the briefs filed by the opposing party that's contended that the language is in any way ambiguous.
Well, here's a problem that I have, if I may. I understand, I can read, and it says, it's usual broad form, all claims, all employees, et cetera, et cetera. I get that on the additional terms of settlement. But it's filed in the workers' compensation matter. It's got the claimant and employer and so forth and so on. And one gets the sense that it was designed because of the caption to release claims under 8520. And of course, the common law claim of gross negligence is not a claim under 8520. It's a separate common law claim. It's excluded from 8520. So your problem, it strikes me, is the caption. I get the language. I think the language is quite broad. It's kind of a common, we release everybody under the sun kind of thing that would definitely include individual employees. But the question is one of scope of the release when it is filed in an 8520 proceeding that doesn't have jurisdiction over a common law claim.
Well, again, I guess this gets back to my point, and maybe I'm not making it as well as I should, but I think there's two things going on here. You have a settlement, and what's the effect of these settlement documents before the commissioner, and what power does the commissioner have? And then you have, as well, you have settlement. There's still a settlement contract. Regardless of what the caption is, if I would have, for example, not filed the additional terms with the commissioner, had the caption, and we were here today,
you'd be in a lot better shape. You'd be in great shape.
Well, yeah, I'd be, but that doesn't take away from the fact that, or the position I'm taking, that this is it's still a contract, and again, there's nothing, there's no authority again that I've been able to find, and nothing's been ever cited that the fact that it has a caption or the fact that it was submitted to the commissioner somehow takes away that it's still a settlement agreement that was agreed to by not only my clients, but and the claimant, but also by another attorney. And so I don't know why another attorney would say, looking at that language, I can sign off on this on behalf of my client, and yet I can still turn around and bring a claim against an employee for injuries that my client suffered arising out of and caused by the same incident that gave rise to the work comp claim. It's just right there in settlement. So you can, I guess at this point I start pointing out and citing to the Thornton case, and I think there's some language in there. The specific language I think is would be most pertinent. I mean, besides the fact that it's unambiguous and it's clear and it sets forth the intent of the parties because it is unambiguous and clear, but they say we will not make a new contract for the parties by arbitrary judicial construction. So I think, with all due respect, looking at the caption of the document is sort of a judicial construction, and I think that's kind of what the Court of Appeals actually got into, was looking for reasons why we shouldn't enforce this as a ordinary settlement contract.
Counsel, what do you make of the argument, I guess, in the Court of Appeals footnote 3 that in essence says you have to read both of these documents together, and that the first document is specific and the second one uses more general terms, and that we need to view the second document, the additional terms of settlement, through the lens of the first document?
Well, I think that sort of ties in with my quote from the Thornton case. I know they cited Amjur and I think a pre-Civil War case for support of that position. But again, these are the 8535-3 document, and then you have these additional terms. Most of those additional terms really aren't within the domain of the Workers' Compensation Commissioner. I mean, the commissioner's not concerned with, for example, the allocation of the settlement funds towards attorney fees, or the allocation of the settlement funds to the claimant over the lifetime of the claimant, so that it minimizes the impact on Social Security. And if you look at those additional terms, there's additional things in there. It goes beyond just what's contemplated by 85.35. 85.35. So, yeah, I think that that footnote, and then I guess the other thing that maybe ties in with the footnote was that I think the Court of Appeals put it on us as the appellee to bring forth case law that supports that this settlement agreement has impact beyond just the work comp settlement, which I think misplaces the burden. I mean, we won at the district court. It's really up to the opposing side to bring forth some authority to support their argument, and I believe this is their argument, that those settlement documents, specifically those additional terms, are strictly limited to what's to matters before the Work Comp Commissioner. And so, again, I think that, again, the settlement language is so crystal clear. There's no dispute about that. So,
Counsel, the Court of Appeals majority took a very narrow focus, and if we left that intact, couldn't you still, on remand, move for summary judgment under your contract argument?
I suppose we could. I mean, there's no,
Are we just postponing the inevitable?
The inevitable, possibly. I think that's quite possible. I frankly hadn't thought of that, but if there's no ruling, there's no contrary ruling that establishes it as the law of the case, certainly I could go back and refile a motion for summary judgment with the district court.
But did the majority read your appellate briefing too narrowly? Didn't you argue the contract argument as well as the the agency approval argument?
Well, I think the judges that decided against us did. Again, Justice May, looked at it as like I'm arguing for you to look at it, which is, we had two arguments. Our brief, we cited cases, in support of the contract theory, supporting that clear and unambiguous language controls the intent of the parties. We made those arguments in the brief. They had issues with regard to, and I think Judge May described it as, failing to make a clear, bright line between our two arguments, but they're definitely in there, and they were definitely argued at the appellate court level. So I think it was, again, I go back, kind of a strained way of looking at things, and I go back to that quote from Thornton about the arbitrary judicial construction, which I think is actually what occurred below. So
Thank you, sir.
thank you.
And Ms. Baumgartner?
Good afternoon. May it please the court, opposing counsel. In this case, I believe that the issues at hand are primarily statutory in nature. This matter stems from a court order which was approved by an administrative agency with limited jurisdiction. So when Ms. Dorothy turns and focuses on the case of Thornton versus Hubble, it's actually not applicable here. That case is a case where they're asking a court of general jurisdiction to interpret and enforce.
Can I ask you a question?
Yes.
I guess I'm not tracking the argument. And so at the time that the parties entered into this settlement agreement, you have offer, acceptance, everybody signs off on it, the contract is valid. Is that correct?
Yes.
And then somehow it becomes invalid because it's presented to the workers' compensation commissioner.
So I guess our point here is more so that once it is presented to the Workers' Compensation Commissioner, it is no longer just a contract. It is actually a court order. So what happens when it goes to the Workers' Compensation Commissioner is they review these proposed settlements. They look at things like causation, medical, the amount of impairment rating, among other things, and then they can choose to either accept or deny those settlement documents, and they can reject them for various reasons. I mean, it can be something as, the amounts don't match up here.
But that contract doesn't have to be presented to the workers' compensation commissioner for approval. I mean,
Right.
Indeed, you're arguing to the contrary, that the commissioner didn't even have jurisdiction to review this settlement agreement. So I guess I don't understand why a contract that's valid at the time it's signed somehow loses its validity because it was filed in a court case.
So our argument is that not that it's invalid as compromised settlement documents, it's that there was no jurisdiction to eliminate all claims as a whole. So that would have been, if we're looking at something like limiting liability or shielding defendants from additional liability, we would typically see things like included but not limited to X, Y, and Z.
But the elimination of the claims doesn't come from the authority of the commissioner. It comes from the terms of the agreement. So if this was never filed, let's say the parties signed it, everybody put the contract in their file folders in their office, and your client sued, then you present the settlement agreement and you move to enforce it. I guess I don't understand. I'm just having trouble following why presentation to the commissioner somehow limits the scope of this agreement.
Because the commissioner only has jurisdiction over 85, 85A, and 86.
So you're saying by presenting it to the commissioner, the employer ends up worse off with fewer rights than they had done nothing? Is that?
Essentially, it becomes a court order at the time that it is approved by the work comp commissioner. So what we typically see in work comp is documents very similar to this, and then a secondary document, which is known as a global release, which is much more in-depth. And it gives essentially that laundry list of claims. So things like we in consideration for releasing your claims, we give you X amount of additional dollars to release civil rights claims or gross negligence claims or whatever employment claim may exist, known or not known, to the claimant. So if that ends up getting put through to the commissioner, they will literally rubber stamp it with lack of jurisdiction and send it back to you. So that's why it's usually a separate document with additional consideration.
What,
Do that doesn't invalidate that global release, does it?
No, but that also shows that both parties had intent to release all of those claims, wherein the actual settlement documents here, the only mention of any sort of claim is relating back to workers' compensation. It's repeated multiple times. I mean, it goes to barred from future claims or benefits under Iowa workers' compensation laws for injuries compromised. So Mr. Terry, solely by himself, not Mr. and Mrs. Terry, agreed to release all future workers' compensation claims under 85. They never agreed under that language to release every sort of claim under the sun. It goes on.
But in the additional terms of settlement, it's all claims and demands that may exist, and then it has the additional language, all liability, including liability under workers' compensation law, all liability, including I mean, the additional terms of settlement document has some very broad release language. Does it not?
It does, but I would re-up the argument that if they were going to have some sort of additional liability that they wanted to shield themselves from, they would have worded it in such that included but not limited to workers' compensation, civil rights, so forth and so on, in order to get that additional included but not limited to language we see when we're releasing a whole slew of claims. That's not what happened here. And the entire settlement, compromise settlement and attached documents make no mention of anything besides workers' compensation. So it's our belief that you can't ignore all statutory aspects and so narrowly interpret an entire document, honing on one sentence to achieve some sort of obscure result.
So should the entire settlement be set aside then? If it sounds to me like what you're saying is there wasn't a meeting of the minds. You're saying that the release of all claims, at least in your client's view, doesn't mean the release of all claims. And if there's no meeting of the minds, you just blow them both up and start from scratch again. Is that what you're saying?
I think there was a meeting of the minds when it was put on that caption, and work comp statute was reiterated throughout the entire document, and then it was subsequently approved by the commissioner making it an order of the court rather than just some sort of general contract.
You're in litigation now disputing the terms of the agreement. It seems like there's no meeting of the minds.
But even if we ignore all that, I think that the four corners of the document show that this is narrow to the work comp portion.
So if the Court of Appeals majority stands that opinion and it goes back on remand, what's to stop the defense from just moving for summary judgment under the side deal or the additional terms that include the release of employees? Is it your position that Mr. Terry and Mrs. Terry did not release Dorothy?
Well, Miss Terry didn't release anything. She was not a party, and neither was Miss Dorothy.
And, okay, was a consortium claim derivative of the injured spouse?
Yes.
Okay, so if Mr. Terry's claim fails, so does Mrs.
Correct.
Terry? Okay, but did the agreement or include all employees or not?
The words, if you hone in on that one sentence, it says that. But when you read the document as a whole, I don't think that's what it says.
Counsel, what principles are we supposed to use in interpreting this document? Is it just contract principles or is it something different?
Well, I think it's also statutory in nature. You're looking at a court order here, and whether or not this administrative agency even has jurisdiction to approve a settlement that waives all sorts of other rights to bring additional claims.
Well, they didn't have jurisdiction over the additional terms, frankly, and maybe it would have been better if the commissioner said, your compromise settlement of all workers' compensation claims are hereby approved, and the additional terms of settlement do not relate to 8520 claims, and I take no position on it. I mean, that's maybe what should have happened and didn't. But the two documents are different. The compromise settlement releases all liability under workers' compensation law. Paragraph B, you're familiar with it. So all the 8520 claims are gone. And then you have this additional document that's attached that must be doing something with all this broad language. And it's filed with the workers' comp. That clearly happens. But does that defeat the plain meaning of the contract?
I think you have to read the contract as a whole, and when it gets down to that part, it also talks about the monetary portion that the claimant is receiving relating to his claims, and those sums, or that sum of money, is specifically relating to his work comp injury and are calculated based upon the specific requirements of the commissioner's rule. So it's a very specific amount, dollar for dollar, given for
Still,
work comp.
it's all one contract still,
Yes.
correct?
Yes.
And because the primary compromise settlement incorporates the additional terms by reference, right?
Yes.
And then if you go to the additional terms, as we've been talking about, it has pretty clear release language defining release parties to include Dorothy, and stating that the claimant releases and discharges the release parties from all liability, including workers' comp liability for the above injury or injuries, right?
Yes.
So I'm still kind of baffled. Where's the ambiguity there?
I think a lot of it comes down to common practice with the global release and what is approved versus what is not approved by the Workers' Compensation Commissioner. It doesn't give a whole list there. It doesn't say anything like included but not limited to. It focuses, again, on that document. It all focuses and relates solely back to workers' compensation. So if Miss Dorothy, LSI wanted some sort of huge global release, it would have been a separate document with additional consideration. There is no additional consideration given for waiving the claims that they are seeking to waive here.
A contract doesn't have to work that way. It can have multiple different covenants and one consideration, right? I mean, one payment.
But I guess my understanding is if you're looking at something like civil rights or an NLRB claim, you need that specific consideration, and there's additional things in there like a revocation period in order to waive and settle those claims.
Right,
that
that's
does not
by
exist
statute.
Here.
Yeah,
Yes.
that's correct.
And that's one of those things that he is attempting to waive here would be something like a civil rights or an NLRB claim, but the very language contained in there in that one sentence that they're honing in on fails to do that.
I'm not sure it would waive a civil rights claim because it talks about a workplace injury on a specific date, right?
But again, if he's talking all claims, our understanding on global releases and our experience with global releases is they're going to give you additional separate consideration to waive all of those claims, that laundry list of claims, not just a one-liner in here.
Well, Counsel, how is this court supposed to factor in the global release that happens, as you say, kind of as a typical practice, but didn't happen here?
They should have asked for one.
But-
Is really my position. They did not ask for a global release in this case, and had they asked for a global release, we'd be looking at a standard contract that would be able to be interpreted in a general jurisdiction.
But why can't this court just look at the four corners of this document?
Because it's a court order. So the court order and that jurisdiction of that administrative agency is limited to 85, 85A, and 86. So they can't even bar claims outside of those statutes, and gross negligence is outside of them.
Would the commissioner, when the commissioner approved this and he saw the 45,000, I think was the amount, would the commissioner have been looking at that amount with respect to only the claims that were before him?
Yes, so that's a very specific calculated under the workers' compensation rules amount, looking at things like the impairment rating, medicals, a variety of things. So that monetary consideration is specifically for workers' compensation, his work injury, and the claim against LSI.
And the parties had to have approval by the commissioner, but before they couldn't come to that agreement without the commissioner's approval, is that right?
So what happens is they'd come to an agreement, they draft it up, and then they send it off for approval. And the commissioner has the power to spit it back and say, no, this isn't right, for a variety of reasons. And they could have spit it back for the amount in there. They could have spit it back for lack of jurisdiction. They could have spit it back for a whole slew of things.
If the second piece of this had not been presented to the Workers' Compensation Commissioner, is that a different case today?
I believe so, because if the second piece would have been drafted in such as a global release.
No, the exact same language, but it just wasn't presented to the commissioner.
I think that's fair, because we could be looking at a just general contract rather than an actual order.
And so it seems like your argument actually vests the commissioner with a great deal of power, because now you're claiming that the presentation of a document that is valid if not presented to the commissioner loses legal effect just by mere presentation.
Well, I think the commissioner doesn't have power to preclude somebody from bringing claims outside of 85, 85A, and 86, whereas that's exactly what Ms. Dorothy is attempting to do in her interpretation of that second document. So I think his power has to be limited to those statutes and cannot affect other types of claims that could potentially be brought.
I'm intrigued with Justice McDonald's earlier question, and he's just now starting to go there again, about how a document can lose its meaning. In this case, if you're saying the contract became an order, isn't that order still going to be pretty darn powerful in another court setting? Couldn't that, quote, order be looked at for its own content and the agreement reached between the parties?
Yes, and I think, again, it just keeps circling back around. I hate to be redundant. To that document reiterates multiple times workers' compensation injury. And so I think that in itself shows the intent of the parties were continually going back to the workers' compensation claim and the workers' compensation claim alone. And I think Mr. Blades brought up earlier about how that
You may finish your thought, and then we'll...
he brought up that they couldn't bring because he brought up intent, and my client would have to have a knowing waiver of his rights, and they can't unknowingly take away someone's right to file a claim. So I think just in my client bringing this in a different forum, it shows his intent was to settle and release claims related to workers' compensation. And then he felt like it was an option to move forward along with his spouse to bring this additional gross negligence claim.
Thank you.
Thank you.
Mr. Blades, you may respond.
Yes, I don't really have anything more to add. I just would urge the court to affirm the district court ruling on as to the contract theory of this case, as agreed to by Judge May. I think former arguments and briefs cover what's been argued by opposing counsel. And so unless there's any other questions on the matter, I would leave it at that, and thank you.
Thank you. The matter of Terry versus Dorothy is hereby submitted. And the other three cases I previously summarized will be taken under, we are now, those are submitted as well, and we will adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.